I'm the Outreach Director for Marsy's Law for Wisconsin. Thank you all for joining us as we mark National Crime Victims' Rights Week with today's roundtable discussion aimed at raising awareness about victims' constitutional and statutory rights. National Crime Victims' Rights Week this year falls at the same time we are celebrating the one-year anniversary of Marsy's Law passage in Wisconsin last April. As a survivor myself, it has been so heartening this past year to see Marsy's Law at work, helping crime victims navigate a criminal justice system they were forced into through no fault of their own. Most victims walk in with zero experience and have little or no understanding of the criminal justice system. And our conversation today will focus on crime victims' rights and will provide practical tips on how to break down barriers to accessing those rights and demystify the process. There will also be time for audience questions at the end, so please make sure you ask your questions using the chat feature. We are joined this afternoon by our wonderful panelists who graciously agreed to be part of this very important conversation. I want to now turn the conversation over to our moderator, Assistant Attorney General Miriam Falk. Assistant Attorney General Falk is the state resource prosecutor and law enforcement trainer for sexual assault and domestic violence. She worked as an assistant district attorney in Milwaukee, assigned to the sensitive crime unit for the last 23 of her 27 years with the office. On a personal level, she has been an amazing resource to me over the last year. Miriam, the floor is yours.
Thank you, Nella. Thank you. I just want to say that in spite of all that experience, I am only, 29 years old. So just so y'all know that. Alrighty, I am so glad that you are all here this afternoon, and I hope that you take advantage of this opportunity to really pick the brains of our panelists today. We have an excellent panel who really understand the system from many, many different perspectives, as you'll hear when I read their biographical information. Marsy's Law has really changed the landscape for us, much more so than some of the other victim rights laws that have already been in place. Marsy's Law has really brought the issue of victims and how the system impacts them front and center for all of us throughout the system. So I appreciate that you will be asking questions. Again, I remind you to use the chat feature and ask your questions. We're going to get to them at the end of our panel discussion. In addition, if you are somebody from media, if you would please include your name and also the outlet from which you are working so that we can identify that for the listeners as well. And with that, I'm going to introduce our panelists to you. Our first panelist is Dane Pelebon. She is a community activist that has been working against oppression in all forms for her entire adult life. She is the co-executive director of the Rape Crisis Center in Dane County, where she leads their counseling and advocacy services and coordinates community partnerships for county-wide sexual assault services. She's also currently on the board of directors for Outreach LGBTQ+ Center and World Builders. Welcome, Dane. It's good to see you today. Our second panelist is Veronica Figueroa Velez. In 2014, Veronica's ability to skillfully address crisis management, community violence, and to develop and implement programs led her to become the executive director of Unidos. Unidos is a nonprofit whose mission is to empower the community to break the cycle of domestic violence, end sexual assault, and promote healthy family systems. Under her leadership, Unidos has increased its capacity and implemented the first and only 24/7 Spanish helpline to support victims in Dane County. Her community activism expands to creative expressions where she uses her artistic abilities to bring awareness to social issues and support community members in their healing process. That is so cool. Veronica has also been appointed by Governor Evers to the Interstate Commission for Adult Offender Supervision. Welcome to you, Veronica. Lee Mills is a nationally award-winning journalist, a small business owner, a wife, and a mom. We may get to see her son in the background there if we're really lucky. She has lived in the Madison area for the last 18 years. And unfortunately, she is also a victim of stalking. The case involving Lee started 10 years ago, and she is still dealing with it today. She looks forward to sharing why she believes the rights afforded to victims by this new constitutional amendment, Marsy's Law, are so important. Welcome to you, Lee, and I really appreciate your willingness to come and do this for us today. Amber Peterson is a legal advisor for the Wisconsin Director of State Courts Office of Court Operations. That's a mouthful, just noting that there, where she manages the Wisconsin court system STOP grant. A STOP grant is federal money that is awarded by the Office of Violence Against Women to improve the court's response to domestic violence, sexual assault, and human trafficking cases. Amber manages projects, monitors, and implements legislation, and provides training and technical assistance to judges, court commissioners, and other legal professionals in a number of areas, including domestic violence and sexual assault. Thank you, Amber, for joining us today, and welcome. And then finally, my colleague, Michelle Visti, was appointed Executive Director of the Office of Crime Victim Services at the Wisconsin Department of Justice in August of 2017. I can't believe it's been that long already. Prior to being appointed Executive Director of OCVS, Michelle was a criminal prosecutor for 16 years in various offices, including the Wisconsin Department of Justice, Dane County District Attorney's Office, and the District Attorney's offices in Waushara, Winnebago, and Outagamie counties. Michelle has prosecuted thousands of criminal cases throughout her career, with an emphasis on domestic violence and sexual assault cases, as well as crimes against children. Welcome to you, Michelle. All right, is everybody ready? Because I think we should start. I'm going to start with you, Lee, because I think let's start really with probably the most critical voice here, our survivor. So the first victim right that is identified in Marsy's Law is the right to be treated with dignity, respect, courtesy, sensitivity, and fairness. And of course, the primary objective for all of the rights that are embodied in Marsy's Law is to both empower the victim voice and to enable victim choice. I mean, if we really have to get it down to the brass tacks, that really is what this is about. And of course, as a whole, these rights are hopefully fostering a cultural climate of respect for victims, as opposed to adhering to stereotypes or biases that could work against a victim. Having been through the experience in the criminal justice system, Lee, how would you describe what has worked and what didn't work with respect to how you experienced the system? And I know in the introduction that you also wanted to talk about how things have changed under Marsy's Law. So if you want to expand on your answer and include that, I would love it.
Well, thank you so much. Thank you for having me. I just want to be upfront because normally I don't get nervous public speaking, but I have these butterflies and I'm sitting here listening to my introduction going, why is that? And I think it's because this is the first time I've ever shared publicly about this one part of my life and the experience I've had as a victim of stalking. So I just want to say thank you for including me in this. And giving me this voice, because there's something really empowering about that. So everyone understands where I'm coming from in my response. I just want to make sure you understand one thing first. And I say this specifically to those of you who have never been a victim of a crime. It's so difficult to understand where victims are coming from if you haven't walked in their shoes. And certainly every victim's experience is different. But for me, when you truly live in fear for your safety, information is the only way to get your power back. And I want that to sink in because it's really important. For me, my case did not end after the conviction. There was extended supervision, a violation of those conditions, revocation hearings, competency hearings, and so much more. My main priority has always been for my safety and the safety of my family. I don't know how to explain the impact other than to say, and this is my truth. I still fear for my safety every single day. And I actually make conscious decisions every single day based on what I've experienced still years later. And I don't think that will ever go away. So every question that I've asked along these last 10 years, every piece of information I've sought has been to make sure that I position my family to be in the safest position possible. And I truly believe that is the goal of victims. So to answer your question, there were multiple things that I think worked. My victim advocate was amazing, still is. We're in communication often, still, as this is ongoing. She calls me right away to give me the date of the next hearing. Every single time something changes, she's on it. She's letting me know. It goes back to that importance of just being in the know and having that information. I feel really lucky to have her. I don't know that everyone operates in the way that she does. I want to believe that they do, but not every person is the same. She's awesome, and we're in contact still as this case continues through the system. Once there was a guilty verdict, and this is something I really feel is important to share for those watching who are victims and maybe haven't thought about this as an option. So once there was a guilty verdict, I had to testify during the jury trial, of course, but after that, it was my wish not to be in the courtroom or in his line of sight for subsequent hearings, specifically if you think about a stalking case, why that would be important. Since I had the right to attend all of the proceedings, my victim advocate reached out to the Dane County judge who was handling the case and asked if I could attend in the media room in this case, but basically in a side room that's separated by two-way glass. So I could maintain this feeling of protection, but still be able to hear what was going on and be abreast of the situation. And I did attend many, many hearings that way. I would have felt forced not to attend, given the nature of stalking, if I would not have been afforded that accommodation. It was a big thing for me, and I'm really appreciative of it. Even after he was released on extended supervision, I was able to invoke my right as a victim to contact probation and parole. This sounds like so jargony, but I was able to reach out to the probation and parole officer, who is separate from, the law enforcement or Dane County DA's office. And that was really important to have just information about how things were going at that point, but also victim witness and the DA's office, and just continue to be apprised of what was going on through every part of the system. It was really important for me to be able to ask questions directly of my prosecutor, Bob Kaiser, in this case, because he was still at Dane County at the time. So during the jury trial, I was able to do that, but really after, for subsequent hearings related to his revocation, once he was released from extended supervision, even more recently, just for help and guidance through a Chapter 51 civil case, which was not Bob's purview, but it's been a huge asset to have access to my victim advocate, to the prosecutor, to the detective in my case, every step of the way, and they've really all been amazing. It was important for me to know my case was moving along. And so if there were any delays, and we all know how long some of these cases can take, I received prompt explanation either through email or on the phone, and that was really important to me. In terms of protection, to just talk about police for a second, the detective assigned to my case did many different things to help me protect myself and also think about my privacy. For instance, when they had a warrant out for his arrest, she immediately called me, "Do not go anywhere. We're looking for him. We will let you know once he's in custody." So doing it once, I just knew when there was a real safety threat that they were aware of, I would know right away. And so that was really important to me to receive that heads up. She even reached out to me to help me think about what I post on social media, what I might say in an interview. In fact, what she said was in my mind when I agreed to do this, because every decision you make, there are so many impacts that you wouldn't think about if you weren't in this position. And once you are, it's just, you become laser focused on that specific element. So she reminded me about not putting information out there that might jeopardize my safety. And we talked through that at length and have had multiple conversations over the years when different things crop up. I was notified when he got out of prison. I was notified when he was on extended supervision, when that warrant was out for his arrest. I mentioned that all again because I just want to make sure I convey that how important it is, especially for stalking victims, to know what is happening for their safety. It's not about the defendant. It's about your safety and knowing what's going on, because I didn't ask to be in this situation. I don't want to be in a situation, but now we all have to move forward. And that's the best way, I think, to help victims as they navigate through this process, to just know that they're supported. Since there are so many different avenues, jurisdictions, I don't know the right word, but so many different groups that are involved, from law enforcement to the prosecutors to the people who care for those who make these choices, etc. I'm hoping I'm not going to go over here. So the things that did not work, I just have a couple of things to point out. And I don't even know, that's a little harsh way of saying it, but my constructive feedback. I had to work a lot harder to get information regarding mental health concerns, which have been a part of this, my case and situation, and including that chapter 51 commitment, which for people who don't know, and I didn't know until this, is just regarding mental health concerns. So I requested through a social worker who was assigned at that point to make my position known to the judge, who was new to our case because it was in a different county. And I was told I would not be afforded the same protections I was in Dane County, specifically that I would be unable to not be seen either in person, or if I was in person, like in a side room, or with no video on the screen. And that was really disheartening. So I mentioned that to just point out that there are differences depending on like where you are. And when these cases go on a long time, you're not always with the same people. When you're with the same people, in my experience, it went great. When you're with new people, it's really hard for them to understand the scope of what you're talking about. On the policing side of things, the one thing I would say is when the investigation initially started, there were many times that there were different officers, because we would call about it and it would be a different responding officer. So I didn't really feel like they were in touch enough, or I knew what was going on, until I had a detective assigned. So when you look at the provision that says there's timely information about the status of the investigation, I would just point out the need to have one contact person, because once I had an assigned detective, it changed everything. And it was so much better. And my detective is amazing. I also learned through the process that when extended supervision is revoked, so the person violates their terms, and then there's a revocation hearing, and then things proceed from there. At some point, it goes to a DOC hearing. And I did not get to attend or say anything that would be taken into consideration once the issue was in front of the DOC, which was frustrating for me as well. And then finally, I guess I would just reassert the times that things worked or the times that things didn't, I feel almost solely relied on people. So when you're in a different county, or you have a different judge, or you have a different agency, or a different part of the process, it becomes a different experience for the victim. Certainly it was in my case. Maybe now with this addition to the Constitution, that will get better. But when it goes from person to person, it's really hard to follow the trail when you want the information to keep you safe, so that you can make decisions that are safe for you. My rocks or my advocate, the police detective and the prosecutor, they were and continue to be amazing. So I would challenge everyone who has the ability to make a difference and maybe isn't a victim who's on this call to think about how this can be streamlined across all sectors of the criminal justice system so that there's more consistency for victims. I always felt that I was treated with dignity, respect, courtesy, fairness. I mean, almost always. And I think it's just the safety. That's the biggest ongoing concern. It continues to be the most important thing. And I'm just honored to be here today to answer any questions about why I believe it's so important that victims are able to participate in the process. So thank you.
So Lee, thank you. That was a wonderful answer, and it was really, really comprehensive. I just want to highlight a couple things from what you said that I think are, some of the sort of the emotional and intellectual underpinnings of Marsy's law. What you really described is how disruptive it is to be a crime victim in your life. And that is true whether it is a relatively minor crime or something that is more significant, like a felony stalking case, or even bigger than that, a homicide case or a sexual assault case. They're all disruptive and life-changing. There aren't very many circumstances where a victim's life is not altered forever as a result of what has happened to them, and particularly in a stalking case. It's actually sort of easy to see from my perspective why that would be. And I appreciate that, what you talked about is information, and as folks are listening, they'll hear that really a lot of Marsy's law is about increasing that information pipeline between the system and the victim, so that the victim has a greater and greater sense of gaining control back over what they've lost, because that really is what you lose, is a lot of control over your life. And of course, as you pointed out at the end, victims don't ask to be part of the system. All the rest of us, I picked to be a lawyer and I chose to be a prosecutor. And so, court is not scary to me. It's very familiar. Even the criminal defendants, they do behavior that they know could end them up in court. But victims, you don't choose any of that, and you lose a lot. So I really appreciate those comments. And of course, the other thing that you said, I think is so true, which is that it doesn't end. Being a victim doesn't stop at the moment that the conviction happens. And for many people, that feeling of victim might last for the whole rest of their life. And hopefully for many people, as a result of Marsy's law, they're going to really move from feeling like a victim to feeling more like a survivor, and maybe even like a thriver. That's what I would really like to see for everybody. And of course, everybody's experience is different. Every victim comes in with whatever their skills and strengths are, and also what their vulnerabilities and weaknesses are. And so, hopefully, as a result of Marsy's law, all of those things are much more on the front burner for all of us. I'm going to turn over to Veronica, who is the victim advocate. And as you said, that advocate, totally a rock. It's completely true. So Veronica, now this is speaking from the advocate perspective. The criminal justice system can be overwhelming and confusing for a victim, even on the best of days. And like Lee, before her experience, most people who have to engage in it as a crime victim don't know much, if they know anything at all, about the system. And of course, what we want to do is to really empower voices and enable those choices by providing notification of victims' rights, notification of the proceedings, and also the opportunity for victims to be heard at these different hearings and to speak with the attorney for the government. So as an advocate working with victims, how do victims learn about their rights? And then who helps them actually enforce them or exercise them when they want to do that?
So victims have access to multiple ways of getting support in communities. And it really depends and varies from community to community. In Dane County, we have the fortune to have so many different organizations that works in advocacy support. We have Unidos, we have the Rape Crisis Center, we have DAYS, we have Freedom Inc., Project Respect, and multiple other organizations that work together to really support and wrap around services for victims of domestic violence. And then also we have the DA's office, they have the Victims Witness Unit that also provides advocacy. So it really takes a multiple approach and effort to working together and collaborating and doing the collaboration piece to really providing the support that victims need. And now with Marsy's law, making sure that that information is not only provided, but the information is also safeguarded and protected for survivors of domestic violence, and also leading the process for the victim to be the one leading that process, right? So we're here now more as a tool than just being here telling you this is what you need to do, or this is what we're going to do. It's actually what is it that you want to do, and we're there to help you every step of the way to make sure that things don't fall through the cracks and to make sure that you're understanding the process. In our case, we are very heavily on people who don't speak the language. So our main focus is the Latinx community. So making sure the victims, when they come to our services, are understanding what the processes are, what the forms are about, what are they signing, what they're getting into, if they need attorneys, to find attorneys for them, if the letters are coming from the DA's office. Sometimes, although they're coming in their own language, making sure that they're understanding what the information is provided, making sure that we're connected also with the advocate that they have assigned at the DA's office, so that we are all in the same page, providing the same information for that particular survivor, and they will all know what's going on here and there. So we're not providing different pieces of information and overwhelming this person. As we know, trauma impacts our brain too, and our ability to retain information, our ability to keep our heads, functioning in a way that we can make decisions that are going to be the best decisions that we can make. So we're there to actually be that second voice of like, everything's going to be okay. It's okay if you forgot the appointment, we can reschedule it. It's not a big deal. We'll make it happen. They understand, it's no problem. And just being that second voice, reminder. Sometimes we'll do reminders. Remember you have an appointment at this time with the counselor, or that you have to go and meet your advocate at the DA's office, or if you want a person to accompany you to any proceedings, we also do accompaniment in court to be there for the victim and to help her understand her rights, what the rights that she or he has to exercise in court, and what are the things, if something happens that this person is not agreeing to what's happening, how can you make your voice heard as well and be with you the whole step of the way. We also help victims write statements, help victims connect with other service providers, and make sure that those connections don't fall through the cracks either, ensuring that we're doing those warm transfers and those connections with other service providers until they are really connected with those providers as well, and answer any questions that victims have, and really just be there to just be that, not only that voice, but that support that just can also be quiet and listen, just talk and do all the talking you want, ask all the questions you have, and if we don't have the answer, we'll find that answer for you, and we'll knock the doors that we need to knock for you every step of the way. So that's the role of advocates really in the lives of survivors. And like you say, victims didn't ask to be victimized, they didn't ask to be put in this position, right? So with Marsy's law, one thing that has happened for us is to really being able to give the victims that power, that this is your case, and you have now all the tools to your disposal to be able to do and go here and go there and present yourself to court and just speak up if you want to. You don't really have to just be happy by just writing it on a piece of paper. You can actually go there and be there, and we can be there with you. You can have an extra attorney if you want to have an extra attorney and you have the funds to do that. Or you can actually talk to the DA's office attorney and just make sure that you're following your case and do all of those things. You have the freedom to do that. And hey, when something didn't go right and you want to make a complaint and you want to talk to the DOJ office for victims' rights, you can do that. You can request information in your language, and you can, go and set up an appointment to talk to people about how these things went, from the police report to how things went for you in this case. And victims are more likely to do that now without the fear of like, oh, they're going to take retaliation against me and they're not going to follow through with my report now, or they're not going to help me to complete my process. And I've been, in 11 years doing this work. Last year through the pandemic, we had a lot of cases that fall through the cracks, unfortunately. A few of my victims who are undocumented said, this is not right, and I want to do something about it. And I'm like, yay, let's go do something about it. And they followed through the whole process for the first time ever, when before they're like, no, I don't want to get in trouble, I don't want anybody to get fired. It's not about firing people, it's about holding people accountable too for your safety. Is your safety. And that's the work that they're supposed to be doing anyway, right? And these jobs are not free. If you're a taxpayer, you're paying for people to protect and serve you too. So let's just take it from that perspective. And these are your rights. And we're gonna, that whole piece of dignity and respect. You deserve that. All of us deserve that, regardless of you having legal status to be in this country. So let's fight for that.
That was great. Thank you. Thank you for that. And just to highlight a couple things from that, this whole idea of collaboration. Now, I know that that's not new with Marsy's Law, but I think that it has really expanded as a result of Marsy's Law. What I have personally seen are communities coming together with many, many different players, many voices, and figuring out how to implement this to really bring to life this law. And I am very proud to say that I think Wisconsin as a state has been not just a leader historically with regard to victims' rights, but also with regard to Marsy's Law in particular, that other states could really learn from us and see how we're doing it. I also really appreciated the emphasis that you gave on trauma, and how, because that really relates back to what Lee was describing too, just really attaching a name to it. And it's very overwhelming. Anybody outside of the criminal justice system, if you experience the loss of a parent, say, or a sibling or a child, that's a trauma too. And anybody who has experienced that knows that you look back on those days following that event and you wonder, like, did I do that? I said that, right? It's just a big whirlwind in your head, and it's hard to navigate stuff, especially complicated things. And so I really appreciate you highlighting that all the different partners in the system, particularly because of Marsy's Law, are really working hard now to be more trauma informed in their response. I want to also mention that there are actually two different kinds of advocates. There is the community advocate, which Veronica represents, and those advocates are confidential. So for the domestic abuse survivor or the sexual assault survivor, if you want to have a conversation and you don't want anybody else to know about it, that's your person to go to, because they, by law, must maintain confidentiality. And a lot of people really feel like they just need to get it out, right? You need to do a lot of listening. The other kind of advocate is in the system itself, and those are our victim witness folks who work in the DA's offices. And they mainly, what they're doing is they're really shepherding somebody from the start to the finish of that criminal justice process. Now, they're not confidential like our community advocates are, and we find that they work together really, really well. They complement each other really well. And again, you emphasized safety and also talked about the ability to really enforce those rights if you feel like something isn't working very well. All right, let's turn to another part of our system here. Michelle, we're going to talk about law enforcement for a minute. Now, I know that you're not a law enforcement officer, but thousands of cases, you've probably worked with tens of thousands of law enforcement officers. And as the director of OCBS, I know that you have a lot to do with making sure that law enforcement understands what they need to do. So we know that often it is a police officer who has the first contact with a crime victim. And we know from having listened to Lee and Veronica now that law enforcement plays a really important role in keeping victims apprised of what their rights are, in fact, notifying them initially about what they are. And as Lee, I thought, really eloquently expressed, one huge concern for most victims is safety. And a specific right in these constitutional rights is the right to reasonable protection from the accused throughout the criminal justice process. So Michelle, could you help us understand a little bit more about how law enforcement does that, helping assure reasonable protection during the criminal justice process?
Sure, thank you. Thanks for having me. So reasonable protection from the accused, as Lee said, can mean different things to different victims. Some victims have significant safety concerns. Maybe their perpetrator is a stranger. Others have safety concerns, perhaps because their perpetrator is not a stranger and in fact is somebody who's very familiar with them. Maybe it's their husband, maybe it's their boyfriend, girlfriend. So certainly it looks different for different people. Law enforcement ensures reasonable protection from the accused by gathering information and from the victim about their safety concerns. And as a victim, the more information that you can give to law enforcement and to the prosecutor about the safety concerns that you have, the better they can protect you. One of the ways that a prosecutor can potentially protect a victim's safety is through bail conditions. And if there's information that's passed along from law enforcement to the prosecutor about those specific safety concerns, maybe it is that the suspect or the accused has a gun or has a whole safe full of guns, and that information is passed along, then the prosecutor can be in a position to ask for a bail condition that there be no possession of any dangerous weapons. Maybe there's a concern that the accused is going to go to the victim's place of employment. If the victim is afraid of that and tells law enforcement that, that can be documented, and the prosecutor could ask that there be no contact or that the accused be required to stay away from the victim's place of employment. So law enforcement can really protect the victims from the accused by collecting as much information and asking about those specific safety concerns that victims have. Other ways that law enforcement can ensure reasonable protection from the accused might be through a lethality assessment protocol. And I know a lot of communities, including Dane County, have lethality assessments that they conduct that would identify situations where victims are at high risk for being killed, frankly, or murdered by the accused, by their abuser. And if those situations can be identified, an intervention can take place that could potentially prevent a homicide. So if it is identified as a high-risk situation, then law enforcement would then connect right on the spot with an advocate and connect the victim with an advocate so that the advocate can go over a safety plan with the victim. And in that situation, they might connect the victim with somebody like Veronica. Right on the scene, and Veronica could help the victim go through a safety plan. So those are some of the ways. And then of course, there may be situations where a victim is, because of safety concerns, goes to a shelter and stays at a shelter for a while. Or there could be some sort of alarm set up at the victim's house, or additional patrol in that area to ensure that there is that reasonable protection from the accused. Another piece, and really it was the reason why Marsy's Law was passed and created in the first place, is for victims to be notified when their accusers are released from custody. And in the case of Marsy's killer, he was released from jail while the case was pending. He posted bail and he was out in the community, and he confronted Marsy's family, her mother specifically, when she was in a grocery store. And Marsy's mother had no idea that he was out of custody. So that's another way that law enforcement and the criminal justice system in general can ensure reasonable protection for the victim from the accused, is by notifying them. And Marsy's Law does that there's a constitutional right a victim has for notification of when a accused is released from jail or prison, obviously, or escape, or death as well, but that's a little less relevant for this discussion. But the escape or release from jail or prison, the victim has a right to be notified of that if they want to. And there are actually automated systems in place that allow for that. There are two systems. One is called Vine and the other is Notice. Vine in terms of the county jail, notification from the county jail, and Notice for release, Notice, NOTIS, notifies victims of release from prison. So those are all ways that law enforcement can help in identifying and ensuring that the victim does have reasonable protection from the accused.
Thank you. And that's really a wide variety of things. And of course, also, I mean, if individuals are violating the law while they're out on release, they're, violating a no contact order that is a condition of bail, or the victim has gotten a restraining order and they're violating the restraining order by driving past the victim's house. We also know that law enforcement will investigate those cases as well and will bring them in, and prosecutors can charge those and maybe have that offender put back in custody then if they can't abide by the rules. So I really appreciate that, the breadth of things that you described there, Michelle. And while I have you still, let's talk about another set of concerns, which is getting restitution, right? There are losses that often happen for victims, and it's important for many people to be compensated as much as they can be for what they've lost. And also for victims to let the court know how this crime has impacted them. And one of the rights it relates directly to restitution. Another right relates to being able to notify the court about the physical, psychological, and economic impacts, and also to get help receiving restitution. So I'm gonna talk to Amber in a little minute about how the courts are involved with that. But I am interested from your perspective, Michelle, on how it is that a victim can work with a prosecutor to obtain restitution, and what are the kinds of things that can be received as part of restitution.
Thanks, Miriam. There are a number of things that victims can seek restitution for as part of a criminal case for their losses, to compensate for losses that they've suffered as a result of their victimization. So I'm going to name just a few of the most common ones. There is a long list, but the most common would be medical expenses, counseling or therapy expenses, physical therapy, the repair or replacement cost of property that was stolen, damaged, or destroyed. Lost wages is another very common restitution that is sought. Funeral expenses if there is a homicide that takes place. And also victims can obtain future counseling expenses in certain sexual assault cases up to $10,000 if they are undergoing counseling and will continue to do so in the future. Restitution also allows for insurers to be reimbursed and attorney's fees if a victim has brought a civil suit, for example, in the case of like a property crime, to try to recover that property or the money from the property that was stolen. What restitution doesn't cover is pain and suffering. I know that's a common question we get asked, so I just thought I would mention that. Ways in which a victim can work with a prosecutor to get restitution and on the issue of restitution is first to keep all documentation that you have of any losses. So any receipts for any replacement costs, any estimates for repairs, any doctor's bills, medical bills, or invoices that you receive, start keeping those and start keeping track of those early on. Provide the district attorney's office with copies of that documentation, or law enforcement if it hasn't yet gone to the district attorney's office. You can notify law enforcement that you've had those expenses and provide them with that documentation. I also think it's important to notify the district attorney's office, typically victim witness, early on if restitution is going to be requested, and if it's critical to you, if it's very important to you as part of the resolution of the case, that it get ordered and that it be paid. So my point is, if that's something that is critical to you, is getting that restitution, you could potentially ask the district attorney to make that part of the resolution in the case, that you receive that restitution upfront, or that there be some sort of payment plan that's put in place as part of the resolution to ensure that you get that money back. Maybe in your case, restitution is not the most significant concern for you. Maybe you're more concerned about your offender going to jail or getting counseling or whatever the case might be, and the restitution is secondary. That could be the case. That is the case for many victims, but if it is important to you, make it be known. Additionally, I would point out crime victim compensation, which is administered by my office. That's something that you can apply for. And if you qualify for it, you will get reimbursement immediately. And when I say immediately, I mean, within a few months or a month or two from applying and being found to be eligible. You can get reimbursement for those losses rather than having to wait for the offender to pay you restitution. And then the state, my office, seeks restitution from the offender. And then it's not your problem. You don't need to worry about it. So that's something that you could ask victim witness about as well. And I will turn it over to Amber to talk a little bit about restitution collection from the court's perspective and options that are available through the clerk's office and courts for collecting restitution.
All right, thanks, Michelle. So like Michelle said, there's a lot that goes into restitution collection, and depending at the point in the case and even in the county where you are, there might be different people who can or will collect it for you, but there might be situations where victims are expected to collect on their own. So generally, if a defendant is in prison or jail, or under supervision by the Department of Corrections, in a lot of counties, if that defendant was ordered to pay restitution, the Department of Corrections will help facilitate that collection of restitution. Oftentimes, payment of restitution is a condition of probation, for instance. But there's a lot of times where perhaps the probation ends and the defendant still hasn't paid the restitution. They're no longer going to be under the supervision of the Department of Corrections. And so then the big question at that point for victims becomes, who's going to collect? Is it now the victim's responsibility, or is there someone else that could still help them collect? Because it is a difficult process to go through, and certainly looking at it from a trauma-informed perspective, it's hard from a victim's perspective to think of, filing a garnishment action against someone who you potentially are still very much in fear of. So depending on the county, there might be options. Over the years, several clerks of courts offices in each county have started collecting that unpaid restitution for victims. So in other words, once the defendant is no longer under the supervision of the Department of Corrections, the clerk of court's office then might take over that collection piece. So a judgment is issued, and the clerk's office will take over collection primarily by sending it to the Department of Revenue at the state. If that's the situation, it's really a win-win for victims. Victims don't have to take any further action at that point. Any money that is collected then will be sent to the victim by the clerks of court's office, hopefully until the restitution is paid in full. One of the challenges, though, and I'm glad that Lee mentioned this when she was talking, is that depending on the county that you're in, practices may vary greatly in a number of different areas, not only restitution collection, but in areas regarding privacy and what types of accommodations may be given. So it's just important to have those conversations, use your victim witness as a resource to figure out what is happening in your particular county, and in particular with regard to collection of restitution.
Thanks, Amber. I'm probably going to come back to you in a second, but I do want to talk with Dana for a second about another really important right, which is the second right that has been identified in Marsy's law, and that's the right to privacy, something that you also mentioned, Amber. Now, Wisconsin, unlike everywhere else in the entire United States, is unique in that we have made the right to privacy a standalone right here in Wisconsin, because we recognize how extremely important privacy is to not only that sense of control, but also to safety. And what I'm hoping, Dana, that you'll be able to help us understand a little bit more is the kinds of things that victims often have privacy interests in, and how the various players collaborate to help them protect privacy. Because of course, from one person to another, it can be really different. And even as the proceeding moves through the course of events, what is important now might not be as important, or might be even more important later on in the process. Dana?
Absolutely. So the right to privacy, as we talked about, is an important right. And I want to recognize that before Marsy's law, predecessors like Jamie, Veronica, M. Adams, these are people that worked really hard to make sure that victims were receiving as much privacy as possible. But with the codification of this language in the law, the things that I'm able to tell my victims is, you can say things that you didn't think that you could say before. Your mental health records are not necessarily going to be trotted out in front of the court and talked about. The economic impacts of your assault are not going to be utilized for ill in a court case. So when I'm meeting with our marginalized victims who already have some reticence interacting with law enforcement or the criminal justice system, to be able to say, you have rights. And one of those is the right to privacy, making sure that your name and your address are not a part of any of the cases, making sure that the conversations that you have with your advocates are confidential. And cannot then be utilized to discuss your mental state. Trauma affects people in many different ways, and how people then respond to trauma doesn't necessarily fit a perfect victim, right? So some of those responses may not necessarily be the most healthy responses, and those responses then shouldn't be weaponized against victims in a court of law. And so what Marsy's law does that we are very appreciative of is that it adds another layer. So if the defendant's attorney is saying, I want all of the records, the judge can put a hold on that. And the judge can say, stop, we're going to take a look at these records. Are they relevant to the case? Not just relevant to that person's mental health. So for us, Marsy's law is another layer of protection that we can say, not only are we working individually to make sure that your privacy is covered, but this is a part of our law moving forward.
Thanks, Dana. And I know that there are a whole lot of individual things that also have really taken off since Marsy's law, including, for instance, in the court documents themselves, that the anonymity of the victims is preserved by either using a pseudonym or using initials. There are protective orders that are issued, like you mentioned, medical records, but other forms of discovery can also protect social security numbers, addresses, phone numbers, emails. Records can be sealed. And so even if medical records might be looked at by a court, the court can determine that those records should be sealed, and maybe we'll only give a small portion of a record if it's relevant, and we'll make sure that other personally identifying information is eliminated from what it is that is made known to the defendant. And even partners working with the media have determined that what is private to somebody from one circumstance to the next might dictate that sometimes information that we used to give all the time, we don't give out anymore, because we recognize that it could feel very violative of that individual's privacy. Amber, I wanted to throw the last ball back to you here. And that is with regard to what we've seen with COVID, which is remote hearings. So can you tell us a little bit about that and how that works for victims, and also how it impacts privacy?
Sure, absolutely. I know we've all probably experienced times when we have to look back at this last year, and despite all of the hardships, there have been some positives that came out of it. And I think definitely one of those was the need to shift for courts to continue to be able to hold court when courthouses were closing. And to do that, the director of state courts issued Zoom licenses to all of the judges in the state. And many counties around the state had shifted to conducting hearings remotely. One of the really great benefits that came out of that we are hearing about consistently is how that has afforded victims many more options in how they appear in court. And so I appreciate that Lee said, even years ago before we had this, she was granted that opportunity. It makes a significant difference to victims to not have to be in the same room as the defendant that they may be in fear of. So I will say that as kind of a consistent theme is the practice does vary from county to county, but that's another important piece to recognize, that it is possible that you might be able to appear remotely, and again, to work very closely with your victim advocate to request that, and to request it as much as possible in advance of the proceedings so that courts can hopefully make that accommodation. With Zoom, another thing to just keep in mind is if a hearing is being held remotely, there's two ways to observe that hearing. You might choose to be in that actual Zoom proceeding as a participant. The benefit there is that if you do want to say something to the court, which you are allowed to do under Marsy's law, if you want to be heard, you can have that direct conversation with the judge and be heard. The downside to appearing by Zoom in that Zoom proceeding, though, is that if you're appearing by camera, your face might display. If you're calling in, your phone number might display. There are ways to get around that, but it takes some coordination either with the judge changing your phone number, or you could appear from the victim witness office and have that number as the number that displays. Another option, though, is now some proceedings that are held remotely are cast using YouTube or another service called Daycast online. So it is possible that if you just want to see what happens, but you don't want to talk to the judge, you could also observe those hearings anonymously at your home using that online feature. Again, this varies from county to county and even proceeding to proceeding, but it is an option and something that's important to talk to your victim witness about to see what's available in your county and for your specific hearing.
All right, Amber, thank you very much. So I've been monitoring the chat and nobody out there has yet asked a question. So don't be shy. If you do have a question, this is the time to write it in the chat. And while we're waiting for people to put in their information, I guess what I'd like to do is, one of those like quick man on the street kind of things, just go through each of you to see what it is that if your loved one, your child or your sibling or your best friend were a crime victim, what would you say to them? What advice would you give to them? And Lee, I'm going to start with you.
Okay, hi. I would say be patient. Make sure that you think about how, the things that you can control, how you want them to play out, and ask for those things. Use the resources that are available to you immediately, and no question is a bad question, and people are available at all hours of the day. I've spoken with my victim witness advocate at 9 o'clock at night. So I think remembering that people are there to help you, they want to help you. The other people in this Zoom have chosen their profession because that's what they want to do. And so don't feel bad about asking for help, and recognizing that you might not be able to do it alone, and it's hard and it's okay. And you're gonna, there are people behind you who want to hold you up through the process.
Thank you. Veronica, what would you say?
I guess if it's a family member, I wouldn't treat a family member any different than I treat anyone that comes to our office. And my first thing would be that you're not alone. We're here for you. We believe you, and we will get this through this together. We're here to help you and support you.
Thank you. Oh, go ahead.
As hard as it is, we're here for you.
All righty. Dana.
How you choose to interact with every aspect of the system, you have choices, and we want to make sure that you are empowered to know what those choices are and how to maximize those choices for your protection and for your healing.
Michelle.
You all said such good things. I would say there are resources, and I think that take advantage of them. I know it's similar to what Lee said, but there's an army of people who are out there working to help you, and so take advantage of it.
Thanks, Michelle. And Amber, and then we have one question that came in.
Sure, similar to what others said, I would want to set realistic expectations. The unfortunate reality is that even in the best case scenario, these cases likely will not wrap up as quickly or end as perfectly as someone would like to know. So that said, I would want them to know that, but to also reassure them, as everyone else said, that there are people out there that they nonetheless can experience little wins and victories along the way and can control the things that they can control, but the rest of it to just be patient with the process.
Right, it is, again, and we must be patient with our victims too, right? So our question, I think, is probably best answered by Michelle, and it is about what kind of information a victim could give in a hearing that's not a bond hearing or not a sentencing hearing, but one of those in betweens, like say a plea hearing. What are the kinds of things that a victim can say at some of these other hearings?
Well, I mean, it does depend on the purpose of the hearing, but let's use a plea hearing, for example. The victim, at a plea hearing really could say whatever they wanted to say, but I think what is most relevant at a plea hearing is, I'm supportive of this plea agreement, or maybe I'm not happy with this plea agreement. And I understand that that's not, it's not the sentencing at that time, but still a judge probably will want to know whether or not a victim is supportive of a case resolving and resolving in the plea agreement that's been reached. It really depends on the hearing, though. Obviously, at a restitution hearing, it's going to be different. Let's say that there is a hearing about scheduling. That will be a very common hearing where a victim may want to be heard. Obviously, the judge will want to know whether you're supportive of having the case rescheduled or whether you want to move it along at a faster pace. And like Lee mentioned, cases take time. They take a long time to go through the system. So that would be a common hearing where a victim, I think, would be providing input and want to be heard. And it's important that you make your voice heard because it will have an impact. And I know firsthand from, experiencing it myself as a prosecutor, and then also hearing from others that when victims speak up about moving a case along, judges hear that and they will.
I would add to that too, that in my experience, I think that people will work to accommodate a victim around schedules as well. So even if it's just a scheduling hearing, that might not seem all that important to some of the players. To a victim, it can be huge, right? And so you don't want to have a court hearing on your birthday. You don't want to have a court hearing when you have a final exam. And so you also have a right to let the court know, and certainly let the attorney for the government know that there may be scheduling issues that you have that are important to you, or even, the configuration of the court might be something important. So, if you are experiencing, say, a threatening look or gesture that's coming from an offender, that's something that I think a court would want to know as well. So there's really a wide range things that could be appropriate for you to inform a court about, either something very personal to you or something about the way that the configuration of the court is, or the way that the proceedings are, and not just your view, although this is also important and relevant, on conditions of bail, or on whether you like or don't like some provision of a plea agreement, or what you think should happen at sentencing or not. I mean, you can have no opinion as well, and that's okay too. I didn't see any other questions. There was a private question, Michelle, that came in that I think you and I can answer offline. But I want to thank everybody for participating in this. I really, really appreciate this. And this is my third one this week, and I learned something new again. So I really thank you all for joining us and for offering your wisdom and your information to our citizens in the state. I'm gonna go back to you, Nella. Nella, you're still muted. Can't hear you.
And you would think that I learned by now. It's been over a year. Thank you, Miriam, and thank you again to all the panelists. I echo your thoughts, Miriam. What a wonderful and thoughtful conversation this was. On behalf of Marsy's Law for Wisconsin, I want to thank everyone for attending today's event. Have a wonderful day, everyone.